Hey everyone, my name is Victor Manibo, and I am one of the attorneys for my own office. And today we're starting with a brand new YouTube show. We have shows about valuable life tips from the A&J show, and we also have a show about current events with Jean Wang, our lead attorney. And now we have this new show called the A&M show. And the A&M show is A for Ariel, who's my co-host, and M for me, Victor Manibo. So welcome everyone to the new show from Wang Law Office, the A&M show.
Yeah, I'm the host, Ariel. Our show going to start every Friday.
Right. So let me tell you about this new show. So our show is going to be all about immigration and frequently asked questions about different kinds of immigration topics. We want to hear questions from the people viewing this show, our clients or potential clients, or anyone who's got a curiosity about and want to learn more about immigration topics. So that's what we're going to be talking about every week. So hopefully as we go along with this show, we get more questions from the audience, from people who are watching, and obviously we're here to help answer them.
Yeah, Victor, can you introduce a little bit on your own background?
Sure. I am, like I said, an attorney here at Wang Law Office. I've been working here for 10 years now. I've been a lawyer for about 11 years. I graduated from the Cardozo School of Law in New York City, and my main focus as a lawyer is immigration and the criminal consequences of immigration and how that impacts immigration, and also civil rights lawsuits.
Yeah, this week we're going to talk about I-130. Then what is I-130 petition?
Right, so I-130s are a very common introductory topic for people who are learning about immigration for the first time. They hear about the I-130 or they hear about a petition for their relatives, right? Because a lot of immigration in the United States occurs through family. A family member brings another family member in from outside of the country, and that's usually done through the I-130. I-130 is the name of a form, and what the form does is it allows someone to petition for a relative so that they can get immigration status. So that's the basic explanation of what an I-130 is. The technical name of I-130 is a petition for alien relative. Petition meaning you're asking the government to do something for you. Alien is someone who is not a U.S. citizen. We're trying not to use the word alien too much anymore because it doesn't seem very welcoming, right? But a lot of our immigration laws still use the word alien. But all that means is someone who is not a U.S. citizen. And relative. Relative just means someone you are related to. So what the I-130 form does, the petition for alien relative, is it's a petition. You're asking the U.S. government or the U.S. immigration system to recognize one of your relatives.
Then who can file this I-130?
So the I-130 form is filed by someone who's called a petitioner. So as a petitioner, you're the one asking the government to do something for you, right? And you're the one who's asking the government, please recognize my relative. So the petitioner is either someone who is a U.S. citizen or someone who has lawful permanent residence, or what we call sometimes a green card, someone who is an LPR or has permanent residency.
So is there a group of people cannot file this I-130?
Well, if you're not a U.S. citizen, then you can't file it. If you don't have lawful permanent residence, you can't file it. But also, even if you are a U.S. citizen or if you are a lawful permanent resident, you might not be able to file an I-130 to recognize your relative. That's because in the United States, to petition for a relative, it's usually only for certain types of relationships. Usually it's the closest family relationships that you have. So it's like a parent or a child or a spouse or a sibling. So going back to your question, some people cannot file an I-130, such as grandparents, a relationship for a grandparent and a grandchild, or like an uncle and an aunt, a nephew and a niece, cousins, and parents-in-law. You usually cannot petition, you definitely cannot petition under those relationships.
Then you mentioned some of the people can do it, right?
Right.
So can U.S. citizen and green card holder file the I-130 for everyone or
Right.
the relative?
So no, you can't file just because you're a U.S. citizen or an LPR. You can't file for all your relatives, right? It also has to be, again, a specific kind of relationship. And for that, like I already mentioned, it's either your spouse or your parent. If you are over 21, you can petition for your parent or your child, and by child, that's someone who is legally defined as a child that's going to be under 18, and your siblings. You can petition for your brother or sister.
That's for U.S. citizen, right? LPR cannot file for the sibling.
Right. So for LPRs, you can petition for your spouses and your children, but you cannot petition for your parents or your siblings.
Then how many I-130 petition I can file at one time?
I mean, you can file like as many as you can, like, as long as you have that qualifying relationship, as long as it's an eligible kind of relationship. For example, you might be a U.S. citizen and you have 5, 6 children who you want the government to recognize that, oh, these are your children. And you can file as many as long as the relationship is there. There's no limits.
Usually some people enter without status, right? So
Yeah.
if the relative can apply the status, file this I-130.
Okay, so that goes into a discussion about status or legal immigration status. The I-130 is something that you can use to get valid immigration status, but the I-130 is not status. It doesn't give someone permission to stay in the U.S. All the I-130 does is lets the government know or allows the government to recognize certain relationships, right? Mm-hmm. So if your parent or your spouse entered unlawfully, for example, maybe they crossed the border, or maybe they used fake documentation, those are big problems, obviously. But that doesn't prevent you from filing an I-130 petition for them. You can still file an I-130 petition for them, even though they're in the country after entering unlawfully, even though they're in the country without immigration status. That's not going to prevent you from filing a petition for them.
Then what kind of document are you going to need to file this I-130?
So let's go back to what the I-130 definition is, right? So I said I-130, basically you're trying to ask the government to recognize the relationship. So for that, you just have to think about what are the documents that establish a relationship. Obviously, USCIS has a list of requirements on like what kind of documents you have to submit depending on the relationship you have and depending on the status that you have. And some examples would be, for example, if you are a U.S. citizen petitioning for your spouse, what is the proof that you are really married to this other person? That'll be the marriage certificate, right? Petitioning for your child, for example, then what would be the proof that this person is your child? It would be a birth certificate. So those are like the kinds of documents that you will be expected or you will be required to submit together with your I-130 form. There are a list of documents, again, depending on the relationship, but it's mostly those kinds of civil documents. Birth certificates, marriage certificates. There'll be other types of proof, especially when you're talking about marriage, and we can go into that also because there's, I'm sure, a lot of questions about like marriage petitions. So
yeah. So what to expect after filing I-130?
So let's say you, for example, you're a U.S. citizen and you're filing for your spouse, and then you submitted the form to USCIS, that's the government agency, and you submitted it together with your proof that this is your spouse. So you probably submitted a marriage certificate, you probably submitted the birth certificates of your children, you probably submitted some photos showing that you two are really married. Of course, like there's a fee for everything, so you have to submit a filing fee. And let's say you did all of that correctly, you submit it to USCIS, you mail it in. What happens now? So what happens now is a lot of waiting. Unfortunately, the immigration system is a little bit backlogged, and there are a lot of cases that they have to process, not just relative or family petitions. There's a lot of types of immigration status applications that USCIS processes, and it's a big agency, but there's also a lot of people who are trying to apply for different kinds of immigration benefits. Right now, because USCIS is a little behind or backlogged, I-130 petitions might take about 11 months at the earliest for certain types of relationships. And sometimes they can even take as long as 3 or 4 years.
That's a lot.
Yeah, that's a really long time. It's, for example, like one of the categories is the siblings, U.S. citizen siblings. Usually those take a really long time, a lot longer. It'll take years compared to U.S. citizen spouses. So depending on the category, the wait time might be longer, but in general, they're pretty long right now. And you can check USCIS.gov for the government agency's latest estimates on how long it take. But in general, like I said, the quickest is probably 11 months by their own estimates.
So I want to know, will I going to go for a biometric appointment for this I-130?
Okay, so you mentioned biometrics appointments. Let's talk about that, because I think that's something that our viewers probably are familiar with or have heard of before. Every part of the government, you have to submit your information, you have to submit photos, you have to submit your fingerprints. The immigration system is just like that. Like, you have to submit your fingerprints and they have to take your photo so that they can document you, so that they can process your application. And that all happens in what's called a biometrics appointment. And in the immigration system that we have, they require certain people to undergo a biometrics appointment where they get photographed and fingerprinted. But depending on the application, you might not have to go to a biometrics appointment. Now, with the I-130, which we're talking about, it's about establishing a relationship between two people, right? The U.S. citizen or the LPR and their relative. The relative who is being petitioned does not go through a biometrics appointment. Usually a biometrics appointment is involved when you are applying for immigration benefit or immigration status. And like I said earlier, an I-130 only establishes a relationship. It's not an immigration benefit. So you don't have to do a biometrics appointment just because you filed an I-130 for your relative.
So can I expedite this I-130?
Well, not really. I mean, you could ask for premium processing, which is available for certain immigration benefits. And I-130 is one of those applications or petitions that you can ask for premium processing. USCIS has their own procedure on how to process something as premium processing. But expediting, which you asked about, is something that our viewers probably also heard about. Like, how do you speed up the process? Let's say you already submitted the I-130 and you already asked for premium processing. It's still going to take a really long time, right? It's still going to be like months. And maybe, depending on your situation, depending on your family situation, maybe you can't wait that long. Maybe because your relative is undergoing some sort of hardship, some sort of medical condition, or somebody has an emergency that requires them to be to have status right away, to be recognized as a relative right away. So you could ask to expedite an I-130, and there's a process for that. This is something that a lawyer can help you with. If you have an I-130 that's taking a really long time, if you have a pending I-130, I know a lot of people out there have pending I-130s. If you have one that's taking a really, really long time, you can ask for help through a lawyer so that the lawyer can ask USCIS to expedite your I-130. It's usually required that you show some urgent emergency, some humanitarian reason, meaning something that requires speed, not just because you want it to happen, but because there's something important going on.
So, I'm going to need an interview for this I-130.
Okay, so that's a good question. Do you need an interview for an I-130? Then the answer is it depends. The I-130 establishes a relationship, and there are certain types of family relationships that are not scrutinized by USCIS as closely as others. What do I mean? For example, for a US citizen petitioning for a child, usually if you submit a birth certificate and your marriage certificate with the parents, the USCIS can decide that case pretty easily. It's a birth certificate is pretty good proof of whether or not a person is your child, right? But there are other relationships that USCIS really takes a good look at to make sure, is this real or not? And I think you know what I'm talking about. I'm talking about marriage. There are, unfortunately, a lot of people who engage in what's called marriage fraud because they feel they probably don't have a choice, or they have other reasons why they engage in this behavior, where they lie and defraud the US government by saying that they are married to a certain person, and they go through the process of getting married, the legal process of getting married, but it's not a true marital relationship. There is no husband-wife relationship. It's just something that is on paper. They got the marriage certificate at a city hall somewhere. Unfortunately, that happens a lot, and that because it happens a lot, that's why USCIS takes a close look at I-130 applications for spouses. So, depending on the situation, there is a high probability that an I-130 for a spouse will require an interview with USCIS, which means after you submit your documents, even though you have a lot of documents proving that your marriage is real, like, you have photos from your vacation, you have photos of your kid, you have birth certificates of your kid, even if you have children, even if you have like a house that you own together, you have all these things, like, very clear, like, or at least a lot of people would think that it's clear that you're a real married couple. USCIS still is very likely going to ask you and your spouse to come in for an interview so that the officer can observe you and ask the both of you questions and see if, these people are telling the truth. So the short answer is you don't always get an interview. Certain types of I-130 petitions are more likely to get an interview than others.
And if this I-130 is approved, what happens next?
Okay, great. What happens next? So like I said, the goal of the I-130 is to establish a relationship. If you, for example, are a U.S. citizen petitioning for your parents and the I-130 gets approved, that just means that as far as the immigration system is concerned, you, U.S. citizen, are the child of the parent. That relationship is there. It's recognized as valid. That does not give your parent any immigration benefit. It doesn't give your parent any kind of immigration status. But the relationship is established, and that's very important because for a lot of people, the only way you can validly immigrate to the U.S. or to get some sort of immigration status through family is by establishing some sort of relationship. So you need the I-130 first. A lot of the times you need an I-130 approved before you can apply for a green card. So usually once an I-130 is approved, the next step is to apply for a benefit, usually lawful permanent residency, or what's called the green card.
Then is this I-130, the approved one, going to expire?
Well, that depends because some I-130s are used to apply for a lawful permanent residency while you're already in the U.S., while the beneficiary is already in the U.S. And sometimes the I-130 is used so that the relative who's still out of the country can come in with valid status. The general answer is no, the I-130 does not expire, but USCIS might close or terminate your case if there is not a lot of action or you don't communicate with them after a certain period of time. That happens mostly for I-130 petitions for someone who is outside of the country. But for within the US, if you're applying for an LPR card and you have an I-130, that I-130 doesn't really expire. You can use that I-130 to apply for a green card at any point. I hope you're still eligible when you apply for it. But, people shouldn't be worrying about expiry dates anyway. You should just think about, getting the status as soon as you can.
I heard that we can reinstate approval I-130. Is that true?
Well, okay, so reinstatement, and you said the term reinstatement, that's in relation to, let's say your I-130 kind of, the case got closed or terminated, which again happens usually with petitions for someone who's outside of the country. There's a possibility to reinstate an I-130. Yes, it is possible, but there are very many requirements for that. There are a lot of details that an attorney would need to know and would have to prove to our immigration agencies before an I-130 is reinstated. And it's a little too complicated to explain on a YouTube show right now, but the short answer is yes, it's possible.
So what happened if the I-130 got denied?
Okay, so the I-130 is denied. Well, the first question is why. You kind of have to know, why was it denied? What was the reason for the denial? And from that, if you find out what the reason was, then it gives you options on what you should do next. Sometimes an I-130 can be denied because you don't have enough proof. And your option would be to reapply with more proof. Sometimes an I-130 is denied because it's not the right kind of relationship. Well, you can't fix that, right? So sometimes there are I-130 petitions that have a lot of legal issues. For example, if we're talking about, children who are born when the parents are not married. Sometimes there are legal issues around that. And USCIS might deny your I-130 for legal reasons, according to the law, if you qualify or not. So the option for that is different also. Sometimes you can appeal. So just then, like I already gave you like 3 options, right? Sometimes you apply, sometimes you can appeal, sometimes you can't do anything and you just have to accept the decision, because unfortunately USCIS is right. Sometimes they do get it right. So the short answer is there are a lot of options. If you get denied, it's not the end, but you have to understand why it was denied, and you have to consult with a lawyer so that they can help you with options on what you can do because of the denial. But short answer, you can probably reapply. Like, people reapply all the time. It might not be the best. Like, it's not usually smart to like keep doing the same thing over and over again, expecting a different result. So if you get denied, the first thing is consult with a lawyer so that they can help you diagnose what the problem is and what the possible solution is.
So what if the I-130 petition pass away? Is that going to end the whole case?
So, okay, let's say the petitioner, the U.S. citizen or the LPR, petitions for a relative, and then the relative or the petitioner, the U.S. citizen or LPR, passes away. And, like I said earlier, I-130 petitions take a really long time to be processed. If it's taking 11 months, 2 years, 3 years for USCIS to approve, a lot of things can happen during that period of time. Somebody could unfortunately pass away. Now, in certain situations, if the petitioner passes away before the I-130 is decided by USCIS, then the I-130 petition is just dead. It's gone, can't do anything more. In certain cases, if the I-130 petitioner, the U.S. citizen or the LPR, passes away, the I-130 can still proceed. This is especially in cases of spouses of U.S. citizens. There are exceptions to the rule, but again, there are exceptions. Generally, if your petitioner passes away for a lot of the categories, for a lot of the relationships that are valid for an I-130, that I-130 case is just gone, terminated, no hope. You're going to have to find another relative to petition for you.
So, is my relative be able to work after the I-130 is filed?
Okay, so this is also a very common question because a lot of people want to come to the United States to be able to work, to be able to make a living and improve their situation and help their family. So work is always something that people think about. And when people think about immigration, they think about petitions, they think about I-130. So it's very common for people to think, oh, I need an I-130 so that I can work. But it doesn't work that way. That's not how it is, right? So like I mentioned earlier, all the I-130 does is establish a family relationship. It's not an immigration benefit, and it's not an immigration status. Being able to legally work in the United States is an immigration benefit. It's a benefit that usually comes with some sort of status. You should have a lawful kind of status before you can work in the U.S. There are a few exceptions to this, but generally you don't get employment authorization if you don't have some sort of status. And because I-130 is not a status, it means that an approved I-130 is not going to give you the authority, or it's not going to give you the ability to work in the U.S.
So we talk about working in the U.S. How about traveling within the U.S.? With the I-130, can we do it?
Okay, so traveling within the U.S., well, that's let's take a step back, right? I presume that we're talking about someone who does not have lawful immigration status, and they're in the U.S. already, right? And they have a U.S. citizen or an LPR relative who petitioned for them, right? And now while the I-130 is pending, maybe that relative who doesn't have status wants to travel around the U.S. Now, what does the I-130 do for them? A pending I-130 does not do anything for them because it's still pending, right? And an approved I-130, again, only establishes a family relationship. So it doesn't do anything for them either. Like, it doesn't affect whether or not they can travel around the U.S. But the question is, like, And they travel around the U.S. to begin with. Like in the first place, are they allowed to travel in the U.S.? I mean, the answer is yes. They can travel around the U.S. without status. People, without status, travel to different states all the time, around the U.S. all the time. It's not a matter of ability. It's more a question of safety. It's more a question of whether it's wise for someone to be traveling. Because, as you know, if you don't have lawful immigration status, you're always at risk of being encountered by immigration authorities. You're always at risk of being possibly detained for removal, to be deported, to be sent out of the country. So, the I-130 doesn't really affect that, unfortunately.
Yeah, actually, time is not today, so.
Oh, wow. Okay.
It's 30 minutes already.
Okay.
Yeah.
We still have a lot of questions. I really like this format because we do get a lot of questions like this from our current clients or people who just know Wang Law Office through our different YouTube shows or through our different advertisements. So we do get a lot of questions from
Anywhere.
lines, from anywhere. We get it from emails, we get it from phone calls. So that's why we have this new show, to be able to answer the most basic questions. So hopefully next time we get to cover more. And if you have questions for us, please feel free to send them in by commenting on our YouTube shows, any of the YouTube shows. You can comment on this one or our other YouTube shows. You can also find us online, the app Line, Line. You can also email us. And obviously you can call us anytime to consult.
Yeah, you can continue follow us on YouTube. Thank you. See you next time.
Bye.